the first special session on the theme Industrial Relations Code 2020. And we are indeed very privileged to have with us Mr. S. Ravindran, Senior Advocate, Madras High Court. If I have a little bit of silence, I can play his AV, please. I don't know, have the AV, please.
Mr. S. Ravindran, Senior Advocate at the Madras High Court, has over 43 years of practice specializing in labor and service laws, representing managements before various judicial forums. Mr. Ravindran is an author of several notable works on labor jurisprudence and serves as the Honorary President of the Labor Law Practitioners Association, Tamil Nadu. Mr. Ravindran's expert views are widely published in leading newspapers and law journals, and he has been a frequent speaker on labor law and policy issues.
Let's give him a big round of applause for taking him his time off. Such a senior advocate. He's going to be talking to us about the Industrial Relations Code 2020. Now, my request, Mr. Ravindran, to take it forward, please.
Good morning to all of you. Am I audible? Good morning to everyone. Okay, thank you. I wonder this large gathering, or I'm sure this large gathering would have gone through these core codes probably in once in 2020, like I addressed quite a few webinars. Now, when it was introduced on 21/11/2025 at 3 p.m., by then I had forgotten everything. Really, see, unless you read regularly and you implement it, you live with it. So, in between, some people used to, out of curiosity, ask me, "Sir, that is been implemented." I said, "What?" They said, "Labor codes." What is that? So, it was so out of focus. Now it has come to focus, and I've been watching YouTube's regularly. Quite a few people have spoken about this. And though I'm not tech savvy, I have read a lot of articles in ChatGPT, Perplexity, Gemini, and all those stuff. You just click, as you all know, what is the silent features of IR code? It gives immediately. You need not listen to me at all. You can know there are so many tabulation, past and present. ChatGPT spits immediately. And what is the controversy on that? It gives answer. And what is the salient features? It gives answer. So everything is now available in your iPhone. So when Mr. Matthew gave me the subject, he initially gave me code on wages. Such a disinteresting subject. Not that IR is so interesting, but I was not interested. I was with reluctance. I said no. Uh, then, to my relief, he said, "Sir, IR code is available." So whenever I accept this sort of sessions, I make two conditions. It should be only on a Saturday, and my session should be the first session. Because I know here it started sharp at 9:30. Around 9:45, Matthew gave me a SMS saying, "Where are you?" I said, "I am watching the TV." It was so nice. It started sharp at 9:30, and sharp 10:30, 11 we are started. So when he said that, I was in 2020 PowerPoint presentation was already with me in my mobile and everything. So I went through it. I also watched my earlier webinars, what I was spoken to, etc. Then within 10 days, I found I should not do that exercise at all, because it's all in public domain now. Everyone knows what is the availability of material, etc. So I reoriented my presentation. What AI has not given you is what I'm going to tell you. Because AI, they say next one is, everyone knows, they said there is some quantum will come in future. They will think super fast than manpower. Then I do not know what my role will be in court or judgment. We also merged with AI now. After COVID-19, we have merged. I can, in fact, afternoon I'm going to argue a case before Labor Court Kanjipuram after the session is over. I frequently argue many matters before Labor Court, I mean High Court Madurai also. This technology is so much. Uh, uh, I have been practicing in 1980 onwards. Just to introduce you to this subject, this you will not find in a stuff. As we all know, labor is a very sensitive subject. As it is assumed, it is not so. So politicians are very much reluctant to bring out new changes, etc., etc. For that matter, in 2020, I penned an article in Times of India about this quote at that time. I said, undoubtedly, this is historic. Whether it is landmark or it is pivotal, etc., is for the down the line only we will know. It's historic for the simple reason a government has come out boldly to not make overall the labor laws. To that extent, it is historic. And from 2020 to 2025, the reason is not known. We will leave it to them why it is delayed. So whenever somebody asks me where it is brought into force, my standard reply is no, not yet. And I said it's not likely to be implemented. It may probably lapse. On 21st, around 4 o'clock, one of my clients said, "Sir, do you know where it is implemented?" As usual, I said no. He said, "I am sending you a message." Then I quickly went through the Public Information Bureau. 3 p.m. it has been notified. It has come on public domain. 4:44, some more inputs, how well it is done. Next day morning, full page advertisement on Times of India about this code with the Prime Minister photos, etc. Probably that triggered a wild opposition or a reaction, negative reaction to this code. I have listened to speeches of three well-informed union leaders who are virtually tearing this code into pieces. And some management spokespersons on TV channel, etc. Then I realized there's something terribly wrong with our understanding of the subject. First one, I'll just take you with this background, I'll take you in exactly these three enactments were 1926, then 47 and 48. In 1966, for the first time, National Commission on Labor was formed with India's eminent jurist, Justice Gajendra Katkar. We know what happens to all these commissions. It was forgotten. In 2002, Second Labor Commission on Labor by the Labor Minister, Mr. Ravindra Verma. I had at that by that time I had become a bit familiar with the subject, so I also interacted with him. That also ended. Now in 1982, a mini overhaul took place on the Industrial Disputes Act. Apart from this patchwork now and then, that introduced very many good provisions, and in 84 onwards it was started implemented. Then 2020 IR code 2025. So 66 to 45 is the first move. I don't think ever in anywhere in the world this slowness would have been there. It is slow, very slow. So it was long overdue. Next. But when the legislature lacks, especially in labor law, you will find in civil law, criminal law, revenue law, changes taking place every now and then, keeping in pace. This labor, they all fear it. But this 2025 code, in my view, should have happened in 1990 itself, when economy was completely liberalized, competition was everywhere, foreign companies have come, it's almost a free trade. We are no longer protected environment, driving only Lambretta or Chetak, Ambassador or Fiat. Everything has become open. But when the legislature is very slow, the judicial mind makes it. As you all know, the law is of two types. One is legislative law, another is judgment made law. It is difficult to interpret a legislation, but not so in regard to judgments. But the judgments are uncertain. 3 judges say one thing, next day, a few months, 5 judges say something, another 5 judges say it is not correct, will refer to 13 judges, 9 judges, which are never formed. So that extent it is uncertain. You should read this article by Supreme Court Judge Justice Sinha, which I have shared with Mr. Matthew. When you find time, you can read it. In 2004, he has said these laws are archaic. It should be overhauled. It is outdated. Especially he referred to non-employment issues, retrenchment. He said how outdated it is. When Krishnaya said in 76, if termination is bad, reinstatement is automatic. He said when termination is bad, reinstatement is not automatic. See, that's the shift from 76 to 2004. He said only compensation can be given. Then you should read this 2019 Order of Justice, Anand Venkatesh. It's all available now. He also said in para 17 and 18, it is high time the labor law is overhauled. That case was given in the context of a strike by a union in a Korean company. And we don't mind workmen going on strike. Absolutely not a problem. Advocates, we have gone on strike. Today, in the last few days, there is strike in district courts because e-filing is made compulsory. So strike is not something new, because after all, Madras Labor Union was was the first trade union in India. Binni Mills. Only thereafter, Gandhiji started Ahmedabad Labor Association. So we are not new to unions or strikes. But as Anand said, those days are all gone. So that is also very illuminating. With this background, I will take you to the subject. As you all know, we have a constitution. Constitution, there is a schedule called seventh schedule. It provides for list of subjects in which only central government can make law, and there are subjects in which only state government can make law, and there are subjects in which both can make law. Labor is one of the subjects. But if there is any repugnancy between central and state, central will prevail. But that repugnancy has not taken place, fortunately, all these years. Why I'm saying is, if central government, Congress regime, they have a socialist pattern of outlook. Present government has got more industrialization or make in India goal, etc. Even then, they are very slow. But states have more flexibility. After 1981, the Tamil Nadu government has not brought a single labor legislation, either in favor of the workman or whatever it is. Because in central government as well as in state government, labor minister is very low in the hierarchy. And it is not an interesting subject for the government also. Last well-known labor minister in Tamil Nadu, at least to my knowledge, is Mr. Raghavanandam, trade union leader. He brought two enactments called Permanent Status Act and Subsistence Allowance Act 1981. Thereafter, nothing has taken place. But The flip side is in 1980 to 1990, when I was practicing in labor law, it was very difficult even to enter the labor court. So many workmen, dismissed workmen will be on the corridors and frequent strikes and lockouts, etc. Now, you must be knowing better than me, the litigation has come down drastically. The reason is there is a downfall of trade unions themselves. For that, the reason is engagement of contract labor, trainees, and NEEMs, and other things. And mobility of labor also has gone frequent. No longer somebody saying, I joined, I retired, I married my children, etc. is all gone. For example, in Binni, when a person was transferred, at the time, Udayar family had taken over the mill. He filed a case and he also said, my grandfather worked in Milli, my father worked in Binni. This management came only recently. How dare they transfer me? So the logic may be wrong. So that type of long-term employment of families working is not there. Uh, Clients are, the companies are not withstanding even 4 or 5 years of life nowadays. Uh, and therefore the litigation has also come down. For example, you take one data which I have collected. Kanjipuram Labor Court has got the highest concentration of industries apart from Coimbatore. Till 2025, till date, or till Friday, only 85 cases of termination have been filed. After 11 o'clock, the judge is looking at me and I am looking at the judge. The witness rolls casually thinking the court will be full and there is no work. In Madras labor court, still worse. 4 judges are happily looking at the laptop given to them for court case purpose. Right? I do not know. So this labor is, I am trying to tell you, this labor is not a sensitive subject at all. So one need not be apprehensive about any, those 3 union leaders have said in TV, on 29th of this month, there is going to be a nationwide strike. Let us see what is that strike. Let's see. Next. I'll now go to the 7 subjects. I will not take you to the legislature, etc. You can look into it in your fixed term employment. This is widely discussed subject. Kindly remind me at 12 o'clock so that fixed time employment. This is really a roasted subject by the trade union leaders, saying that there is no protection of employment, it is a hire and fire, whims of the management, etc. We have lost our rights which we got in 1947 Act. Theoretically wrong, factually wrong. This fixed term employment without that title has come into force in 1984 itself by way of that amendment, which says one of the exceptions is termination of employment due to a clause in the appointment order or anything such of nature. Let me understand from 1984 to 2025, in how many cases this appointment providing for termination has been misused? What is the data for this opposition? How many litigations have come to the court? So in industrial belt of Kanjipuram and Chengalpet, Oragadam, all those things, only 85 cases for the entire year. What is a big demo about this class in 2025, when in fact it is in force in 1984 onwards? Now, these all I got through reading the journals and newspaper articles. 15 states, that's why I introduced you by saying it's a concurrent subject. 15 states have already incorporated this class in the state legislation. What is the opposition in those states? Industrial state, Gujarat, Maharashtra, and so many places. Nothing. So we have to live with it. Next. That's why I said there is no large scale litigation in view of this amendment. This hire and fire. It's a usual lingo saying hire and fire. There is no hire and fire. There is hire and fire subject to the law of the land. We are not living in a world, a capitalist country. Ours is not a capitalist country. If you had visited USA, you would know the best example and the worst example of capitalist country is that. Like if you buy a air ticket for a seat with a leg space, leg room, you have to pay extra. Uncontrolled air industry. They book more tickets, and if you come late, your confirmed ticket, you will be asked to come tomorrow. So that's why US Senate called them saying, what's happening it? They said, no, no, there is a cancellation, it will be waste of money. So I'm giving opportunity for others to travel, though they didn't say they are throwing out the valid passengers. So ours is not a capitalist country, uncontrolled by government intervention. This economic crisis 1 decade ago in America is because of uncontrolled money market in this country. We don't have such a, we have RBI, all controls are there. Next. See how meek our government is. 2018, the Tamil Nadu standing orders was amended, bringing this fixed term employment. It was never brought into force. So this type of meekness has come to an end. I fully support this code, though I have certain misgivings or criticism about it, but it has started well. I only hope during the period I practice, there should be a single code ultimately. It's taken 50 years from 29 to 4. From 4 to 1, it should be logically a shorter duration. Okay, we'll go to the next one. But don't be trigger happy saying I have a fixed term employment, I'll fire you. But 1996 itself, the STOL 200BB, Supreme Court has cautioned. See, everywhere in every legislation, you are invested with power. That power is not the end of it. That's only an enabling provision. The exercise of power should be bona fide. That's the ultimate test in labor law. That's why they use the expression social justice. So you can misuse this 2OBB or the present fixed term employment, but your bona fide will be questioned. That's a check on you. Whether you are appointing me on fixed term employment every year and ultimately you are throwing out. Or in the case of Ravindran, Captain Vijay Kumar is taken. Next year, some X is taken. So that will be definitely tested. So use it in a bona fide manner. That's the underlying as far as fixed term employment is concerned. Next. The reason given by the government is, I don't know whether it will be correct or not only. This replaces widespread engagement of contract labor. I don't think so. It's not a correct view because this fixed term employment is with a lot of conditions. The wages should be same and benefits should be given. This is slightly more than 25 Rule 25 of Contract Labor Act, which says if contract labor and company employee do the same work, the wages should be same. This is something much more. And also much touted welfare, gratuity for every year. With this financial implications, I don't think the company will abolish all their contract labor and take them in direct employment. It is only a wrong statement by the government on that. I don't know. Only you should correct me if I'm wrong. So this logic is not correct. As you know, contract labor, we all pay only minimum wages for that industry, and the bonus and everything is on the head of the contract. No doubt we replace it, but that's not the story in fixed term employment. Therefore, use it don't misuse it, because litigation may come, though it has come down. That's my first point on the contract law. Then strike. So the union leaders said on TV, our strike is lost. Our right to strike is lost. We are a strike loving country. We lawyers frequently go on strike. Even now, as I said, there is a strike in district courts against e-filing, etc. Whenever those days I go to labor court in Puducherry or Velur someplace, previous day I'll ask my local lawyer, is the court functioning tomorrow? Number one, is the judge available tomorrow? So subject to last minute contingency. So that much. When I travel from Chennai to Puducherry on the way of somewhere, Marakanam, there will be a call from, sir, today morning our association has announced a boycott. Yeah, I said, why? So there was a clash between the client and the advocate. So we are on a protest. So some reason. I have traveled many places and I also reading all of articles. To my knowledge, subject to correction, only in France and Great Britain, not no more Great Britain, because we have taken over that country as our colony, because Britain took us as a colony many years ago. There is an element of strike, psych is there. Britain, nurses go on strike, doctors go on strike, transporters go on, workers go on strike. In France is also very. Other countries I don't find any much. At least coming to the level of newspaper in world news. So we went on freedom struggle. After we got freedom, also we are in a way we are a very freedom-loving country. Therefore, we are on a strike. Now, the strike is concerned. It is high time our workforce are informed that the days of strike are gone. Let's have a disciplined workforce. Let's have a skilled workforce. Otherwise, the tall claim of saying in another few years we are going to become a fourth largest economy in GDP, etc. At the same time, underestimating our weakness that we have large scale unskilled labor and frequent absenteeism and frequent strike does not argue well for the image of the country. Why China has become a workshop of the world? Productive labor and absolutely no strike. So there should be end for strike. And there cannot be a clamor saying it is my fundamental right, I'll go on strike. Supreme Court has said you have no fundamental right. It is not like a fundamental right to speech, religion, etc. in Article 19. Article 19 does not speak about the strike. But you have a right to go on a legal strike. Legal strike. Now, prior to this amendment, in all non-public service industry, strike is legal. In public utility service alone, there is some restriction. Or you can put it in a very simple manner. All strike in public utility service is illegal. All strike in non-public service is legal. That is the underlying principle if you read the section. But for labor and management, does it make any difference? The strike is legal or illegal, the strike has taken place, we have got affected. The same principle will apply for lockout also. I am not talking it for the time going. Now it has been reduced, saying in non-public service also there should be a notice of strike, etc. So there is a big outcry. Our right to strike is taken away, etc., etc. It is not so. Even now you can go on illegal strike. For this central legislature amendment, there is going to be a labor strike on 29th. Definitely it is not a legal strike as on date. But will it prevent the CI2 dominated companies to workmen to go on strike or not? Definitely they are going to strike. Thereafter, what is that we are going to do? Are we going to deduct 8 days wages or issue charge sheet, etc., etc.? So this is a hyped opposition from the union leaders. Therefore, there is nothing wrong about this provision being brought into force. Next. You also read this judgment, 1996. They have very clearly said a strike means, as per the definition, you only withdraw. No one need to note down because it's Matthew will send it to you by WhatsApp or etc. etc. Strike definition itself will show strike means you just withdraw the labor. I don't go to court. That's not a strike. But this meaning of strike is distorted for many years. So striking workmen prevent the willing workmen or officers, staff, contract labor, others, and they prevent ingress and egress of goods and materials. So is it a part of strike in law? No. The Madras High Court has said it is nothing but hooliganism. I am not saying that. The High Court has said it's hooliganism. You can't cross the Lakshman Rekha. You strike. But that's why line of judgments, even in this case, you will find a next judgment. No, this is Anand English, yes and Y, you will find you should be 500 meters away. You should not prevent anyone. You can get police direction to implement this order. So it is high time the workmen realize that strike is not a powerful weapon which they imagined to bring us down to our knees for their demands is no longer correct. And this amendment has made it more emphatic. Next. Mass casual leave 50%. It's already taking place. Wildcat strike, pen down strike. In banks, it used to be there. So during working hours, they will stay out. And after working hours, this public transaction hours, they will come to the office. And they claim pro rata wages or contract is indivisible, etc. etc. So our country is well aware of all these methods by the unions, at least from 1980 judgments in banks case, etc. So what happens? It does not kill the strike of the workman. If 48% go on strike, what does it mean? Does not make much of it. Strike is a strike. It should be brought down with iron hands. Undoubtedly about that. Otherwise, our country will miss the bus, which we are all hoping to get at some point of time. Next. Yeah, I'm ready. Again, articulating inside. It's not an option to you. It should be exercised in an exceptional situation. When we were also going on frequent strike on all those issues, some of our very young and enthusiastic lawyers went to the Chief Justice's room and shouted slogan. Police persons were standing outside the court hall. They already have a good security system. The only thing is, police are mute spectators. We are more powerful in our place. So police people just watch us. So the striking lawyers went to the Chief Justice Court. If you visited the High Court, you at least visit. There is a walk program once in a month. You should visit it at least for the sake of it being like a museum. These people entered it, shouted. This gentleman from Delhi was shell shocked. Chief Justice Kaul. He is a very bold man. Our advocates underestimated it. So he walked out of the court immediately and he rushed to Delhi to report to chief because he cannot report to anyone. He went rushed to Delhi. The lawyers didn't know that he has gone to Delhi. They went to his bungalow and shouted at him. Then he said, I have no faith in police. So he took the permission of the Chief Justice. So CISF is manning our High Court premises. So every day morning I have to show my ID card, though I am with my full robes. I stand on a podium. I have to stand like that. My case bundles will be scanned. to see whether I am taking a weapon or not. So this is the method of strike in our country. So after the CSF, even if I don't buy, I forget to take my ID card, he says only, sorry, sir, just can't enter the premises. So that now we don't have any strike at all in High Court. There is no strike at all, no shouting inside the court hall, nothing, very peaceful. We are all in a noble profession. So we are conducting ourselves in a way for the past few years. This is about strike. This layoff, retrenchment and closure, uh, pushing it from 100 to 300 has given a lot of negative thought by on the other side. I am saying for the see this has got a history. This 2000 in 1976 for the first time it was when I say 1976, you should imagine our economy, our country's psych, closed door economy, license Raj, etc. That time there was a lot of industrial unrest. 70s and 80s is the worst period for our Indian industry. So probably at that time the government thought the managements are going very whimsically and they are not given their rights in wages, etc. I still remember in 1980s on during that time, every settlement will be preceded by a strike or lockout. It is not so nowadays, as I could find out from the industry. So in 1976 itself, this amendment was brought, not in 2025 the first time. That amendment was struck down on the ground of the lack of procedural laws being sound. In 84, the same provision was introduced, bringing the strength from 300 to 100. So 76 to 84, we had 300. Is there any data to show that during this period, without government permission, you have retrenched large number of workmen? Is it so? Or before 76, where industry is recruiting and retrenching, recruiting and retrenching? No, we need workmen, we need trained workmen. See, retrenchment is due to various economic reasons, business reasons, etc. Therefore, in 84, it was passed. Management challenged it in 1991. It is in force. Now we have gone back to 76. That's all. In fact, I would state when I start an industry and recruit people, start an industry, I have to comply with lot of laws, Factories Act, etc., etc. So that's it. For reducing manpower, why should I take permission from the bureaucrats? Why is it necessary? It defies logic. And everyone knows the government does not give permission at all. So, what does it lead to? Sickness of the industry. And closure is not taking place in law, but in fact, it takes place. Then it becomes bankrupt. Who will get the property first is the competition. Banks, EPF organization, ESI corporation, everyone stand in the queue as to who will have the first hold of it. For that also there is a litigation, it goes all the way up to Supreme Court. So this is a completely unnecessary provision and even this 300 should be removed. I need not take a government's permission. More so, there is a rule of law in our country. Why should I take permission from the government to lay off? See, suddenly COVID-19 has taken place. Should I get the permission of the government for that? Does the government give permission? No. Now, Trump's tariff is there. So, export-oriented industries want to lay off or retrench. Should I go to the government for permission? I have conducted a case of I don't know, it's a garment company. It lost a lot of orders. We filed an application for permission. The government rejected it saying, then many such export companies will come for permission, therefore I cannot grant permission. This is exactly what they said. We went to the High Court set aside it, then they gave some methodology by which we got it. So if this is the attitude of the government, Why should I go before the government and asking for permission? So this 300 is also unnecessary. It should be removed. And there is no need for such a outcry about the way I want to conduct my business. Why should the trade unions oppose my right to do my business? Do I have any say in the trade union function? Nothing. How many unions are registered? How many unions are sending the returns, annual returns? Many unions in my practice, there are letterpad unions. Letterpad unions. Therefore, this should be done away with it. And already the 19 state governments have introduced this provision. In these states, has there been a large scale violent strike against this 100 to 300? Nothing. Nothing. Let me wait and watch. We all. How many days of would be lost due to this new courts? There will be negligence. It's only a shout. Nothing more than that. It does not need anyone to look into this. And I am also told, uh, all of you will be knowing. Next, this even while it was 100, it was mostly in small scale industries. So, to my knowledge, small scale industries are the biggest employment providing sector, not our Hyundai and other companies. Comparatively, they only provide a lot of. So for them, it is 100 or 300 does not matter. Probably this 300 will be having an impact on the medium scale industry, which has got that strength. Otherwise, it is nothing. So this objection to this permission, etc., or I have been suggesting to the government, you have it, even 50 does not matter. But let me get the permission from the court. I am ready because I am waiting for a judicial decision and not a bureaucratic no. So, is the persons who oppose this provision ready for this judiciary being the watchdog for my layoff, retrenchment, and closure? I am fine about it. Now, it's unnecessary two-tier system. Even if government gives permission, in my imagination, the workman can still challenge it. That closure is wrong, retrenchment is wrong, layoff is wrong. So they are not remediless. Therefore, why a sort of a trailer before the government and a full scale episode before the court? Not necessary. We have gone away from all those bad days of industry means Tata Birla. They are rich people, etc. They are squeezing the workman. These are all gone. Unless we give reasonable wages, we don't get talent. So that is the situation as far as this is. So I moved that medium next. So 100 statute, sir, rarely given. So I am ready to go to the court for it. So this is a next subject on permission. Next, conciliation. I am not very sure about it. How many cases have resulted in a conciliation settlement? I do not know. But conciliation is a good forum to avoid direct confrontation. And why this conciliation only in labor laws, or now it is called as industrial law? Because labor means the labor think it is only their favored subject, and is also called labor court. Therefore, they all say the labor should be, the judges should give benefit only to the labor. Why I am emphasizing this is in 1966 first Labour Commission, Gajendra Gadkar named this as Industrial Relations Bill. Probably 1996 itself he thought about it. So we have labor courts, then Industrial Disputes Act, so that it disputes labor courts. And workmen and their advocates tell the labor court, newly recruited labor court judge, when they get transferred, they intimidate him. So, madam, we have a lot of women judges nowadays. Madam, this is called labor court. You should give a verdict only in favor of the labor. That's how they started. I remember many years ago when labor officers recruitment was taking place. For the first time, at that time, Tamil Nadu Public Service Commission chairman, one retired police officer, he was also Mylapore MLA for some time, Nadran. He said this recruitment, he was brought in by Madam Jayalalitha only because there was a large scale scam in the recruitment in Service Commission. So he said, hereafter, in this, my regime, the labor officer recruitment will be manned by one local officer, then one industrial relations manager and a lawyer. So I attended one uh, recruitment process. I asked all the 10 or 15 persons, if you are recruited as a labor, how do you do the conciliation in favor of the labor or mediating the settlement, etc. Everyone without exception saying, I will look into the labor's welfare only. So that starts from the uh, beginning itself. So this conciliation has lost its neutrality in labor disputes. So every conciliation, the conciliation says, sir, why don't you consider them? Why don't you make more payment, etc., etc. And I know a particular union leader was such a powerful man. He was more than the conciliation officer. He will sit in one row. As you know, you've gone to conciliation, two rows, labor officer is in the center. He will sit in one row and he will ensure that all his cases are posted on 1 or 2 days. He will go inside and say, sir, first call this case. So that management will come, they will get a bashing from him. Then he will say, sir, call the next management. So one of my client who told me very innocently, asked the officer, sir, who is the labor officer here? He told me really. I said, why did you ask? He was the person who is sitting in the center is the labor officer. No, no, sir, I was very worried. Probably he is a staff or he is a labor officer. Then very, I don't know what to say, embarrassingly, that man said, no, no, I am the labor officer. Then he said, sir, why he is having such a command over here, etc. So that lost its significance. And the only truth available to the labor officer is refer the uh, no, industrial disputes raised by the unions to the government. That's all the power they had. And they used to give some advice, agreed advice, though no one agreed for it. They will always say agreed advice. And they will compel us to make a signature that we will not take a disciplinary action for going on strike. The management will not victimize the workman. The workman will work regularly, all usual stuff. Apart from that, they were not using any other proactive or any novel method to bring about a strike. So unless you solve it yourself, going to the conciliation officer is only a waste of time. And the conciliation officer asking, have you come in a car? Why don't you leave the car? I need for my personal use. Apart from nuisance like this, nothing happens. So now, one good positive thing is, hereafter, you need not wait endlessly before the conciliation officer. 2 o'clock is your appointment time, they will call it at 5 o'clock. In between, you would have gone somewhere else with management persons for a lunch somewhere else, and you'll come walk in around for those days are all gone. You can just mark your attendance for 45 days or whatever days they're given. Then conciliation automatically comes to an end. It's a big relief for managements. We need not undergo the ordeal of conciliation. And the positive thing about is this relief to the management. And positive is the unions can go to court directly. Go to the court directly. They need not wait for the government to make a reference. The logic behind not allowing a litigation directly by the union is it is not a equal fight between workman and labor. It is not a tenant, landlord, or a debtor or a creditor, etc. They found that fight between the dispute between the labor and management should be minimized and it should be settled. And there should not be frivolous litigations. That's why this is the only field where there is no right of going to the court straight away. You have to undergo the conciliation, and the whims of the government also matters. And sometimes the government, due to management's position, may not refer many cases to the court for adjudication. because the demands are nearly 100 from coconut oil, soap, washing powder. So far, they have not asked for powder, face powder, or cream, or something else. So, all those things will be rejected, and core economic demands like basic DA, HRA will be referred. So, the union advocate will not rest with it. He will challenge it in a high court, asking for a reference. Then I appeared in one such case and argued before the judge. The law is reference is automatic, decline is exception. I told him these are all covered by various legislation itself. Maternity benefit, leave is under the Factories Act. Why should there be a reference, etc.? So those dark days are all gone. Now you will have less settlements and more cases and more advocates, more income. Beyond that, it does not achieve. And litigation should be the last resort. To my clients as well as my relatives or in my personal life, I have ensured that I don't go to court at all. Who will go to court? Who will go to hospital? Both these two places, apart from police station, are not places one would enjoy, would like to go unless you are dragged. So let's see that whether this type of thing will have a negative impact, is what I am looking at it. Now, if you go to the next slide, you will find more disturbing news. We have a number of labor courts in our country and in our state. Chennai has got 4 labor courts without any work because, as I said, the cases are dwindled. I asked my association to write a letter to Chief Justice saying 4 labor courts are not necessary. Since it is a labor law association, they said, no, we cannot write such a letter because labor will feel why we are seeking abolition of labor courts. Then I wrote a letter to Chief Justice. You send any of your officers around 11 o'clock to the court, you see how many cases are conducted, how many judges are idling on the court or inside the court. I said, out of 4 courts, 3 should be abolished, along with one judge, for him a car with a driver, and a 3 personal staff in his court, and about 4 or 5 personal staff in his residence, and rent-free accommodation. I said it's a huge expenditure, unproductive. You abolish the 3 labor courts. Nothing has happened. No, we have so many labor courts, except in Kanjipuram and Coimbatore. After 11 o'clock, there is no work because the cases have drastically come down. Now, if this is the state of affairs, now the code has replaced them with industrial tribunal. The experience of functioning of the tribunals in our country is so bad. It's a nightmare for litigants. That too with an administrative member. So administrative member will come and enjoy his perks. And there will be at least a judicial member comes through experience, undergoing examination, etc., etc. So the administrative member is always a favored post for some bureaucrat, etc. And for him to know the subject is an uphill task. I will assume they will appoint labor law knowing persons like retired joint commissioner of labor or retired labor secretary, etc. But he is already fixed with a bureaucrat mind. And the frequency of post being vacant is such a bad mess. Tribunals hardly function. And one is not having work, one judge is not having work. 2 persons sit and don't do any work. That's the result of it. And the nightmare continues if there is a split among these 2 persons in a verdict, because it should be unanimous. It will refer to a third judicial officer. So that person should be appointed and he will give a verdict in favor of one of the persons. Therefore, it becomes 2 versus 1. The 2 will prevail. This is most backward amendment I have come across. No one asked for it. No one wants this. When we are asking for abolition of courts, we are thrusted with 2 persons instead of 1 person. Now, next. this will be disadvantage for both, because the workman will get restless waiting for the cases. I have heard some workmen come to the court and saying, "Sir, my case is not being completed. My family is starving. I will going to commit suicide," etc. Now, the managements are concerned if there is a litigation on, for example, PF, Provident Fund cases. I've been conducting PF cases ever since the tribunal came into being. From 2014 to 2025, cases are still pending. If 1 lakh is a litigation, interest on that will be 2 lakhs, and the damages will be another 50,000, etc. Who wants this type of litigation in our country? Litigation should be speedy and cheap. It is not happening at all. So this tribunal is disadvantage both to the management and as well as to the workman. Now another insertion is uh, uh, in a non-employment case, the workman have to wait for their verdict. If he succeeds, he will get full back wages or half back wages or nil back wages. No. Now a power has been given to the labor court to grant interim relief during the pendency of litigation. That is, you dismiss a workman, but still you are liable to pay interim relief to the workman, and that litigation will go on for many years. I don't know what is the logic behind this setup of an insertion in this code, whether it is in favor of the workman or it is against the management, etc. But it is also quite unnecessary. No one asked for it. Next. I have a word about this. Now it is termed as tribunals. So tribunal means labor court means third class, tribunal means first class. Some sort of imagination. And senior judge, super senior judge here. There is a rank in district judge. District judge, super district judge. That's all. The court also, the tribunal, entire state there is only one tribunal. It will be a very nice place to sit, unlike like a labor court. That's all. The atmosphere will be better. Nothing else is there. Now, between 50 and 50, I'm only testing the logic of this industrial tribunals. Between 50 and 56, there were labor appellate tribunals. Underline it, appellate tribunals. Against the order of labor court, you can file an appeal to the tribunal. So it was functioning well. Mostly the litigation would not go to the high court at all, because two decisions on facts will not be entertained by high court. Now that was disbanded by the government, saying the tribunals are taking long duration to dispose of the appeals, not trials. Trial means examination of witnesses, etc. So appeal is taking long time, therefore they disbanded it. Without knowing that history, now it has come back to haunt us in 2025. So a lot of correct thought process has not got into this. I am completely upset with these tribunals. I have a feeling that hereafter I should not practice this trial at all. Go to the High Court and good money. Why waste my time in the tribunals? It is quite negative in nature. It should be withdrawn, actually. Though it's not going to happen. Next. This 300 workmen, I already, standing orders. This is a standing order, is a dead legislation. They could have retained the name standing orders and left it as it is. How many of us are enforcing standing orders in our day-to-day life, disciplinary action, all those things? It is there. Anyone asked me saying, "Sir, we have to take certification. Will you help me to draft it?" I said, "Take the model. That's all. Then nothing more than that you can do." And officers also don't certify anything more than model. I don't know why this threshold was increased to 100 to 300. I don't know. It is also attacked by the unions. I don't know what is the favor of ease of doing. They termed it as ease of doing business. Not having a standing order is not good for the industry. We should all have a standing order so that workman will know what is the service condition. We also know our rights and our limitations. Now, fortunately, as I started in the beginning, it is in the concurrent list. Earlier it was 100. Now, state government has amended it, saying even 10 persons in a factory you have to certify standing orders. So I suppose the state government will step in and increase it. This thoughtless procedure does not merit any acceptance. Okay, 20, I'm sorry. Next. Trade union uh, is an unwanted person in our scheme of things. Little realizing the first trade union was in Perambur and first strike was organized by them. We do not know correct history of who started this union, Madras Labour. Some people say Kalyana Sundaram, the great poet, started it. Some said some Naidu. Some said another of Sindhi persons. Anyhow, when this trade union went on a strike, the Binni movement imposed uh, uh, fine on them for the loss of production suffered by us. And the movement wanted to be relieved of that. They gave one condition. This union leader should resign from this factory, then I'll give it up. So that's the history of trade union. Then government brought an amendment saying the unions will not be made liable for this type of penalty, damages, etc. Now, this trade union, uh, yes, uh, there is no law on recognition in our state or in central. So that has given why there is no recognition 1926 onwards when so many things can happen. Because the unions themselves are not sure whether they should have a tag of recognition or not. Because if you are a minority union, you will not be recognized. But if you are a minority union still favoring the movement, you will be recognized. There is no stamp of recognition in law. In practice, I recognize, in practice, I don't recognize. You are a troublesome union, I will not recognize you. I will not call you for negotiation. You are a friendly union, I will recognize you. I will call you for negotiation and sign a settlement. This is somewhat chained, the attitude of the movement is chained in unfair labor practice, schedule, etc. So there was no recognition. Did this help us? I do not know. Non-recognized law, did it help us? Is a question which you will all answer, but I don't accept it. We should know who is the bargaining person. I have filed a case before the Madras High Court about 300 workmen, about 10 unions in Pondicherry. Rahul Gandhi Union, so and so union, etc. So everyone had 5 representatives. So 10 into 5, 50. Out of 250 or 300 workmen, attendance let me take 200. 50 persons will be regularly having negotiation with the management. So we wanted to have a recognition, and the labor, joint commissioner of labor, he said, this is not a lawful subject. I will not handle this. So we had to come to the High Court and plead with the court on 2 issues. One, conduct a secret ballot. It's a democratic process. Or let the government have a check-off in terms of the labor code. Code of conduct, which is an agreed advice in all India level, but is not a statutory level. So one particular union had got 60, so that was recognized. Next year, some other union, Purachit Talavar union came, so it became a big nuisance. This puts in order 51%. If not 2020, you will be the person. You will have a life of 3 years or 5 years. We will know to whom we should negotiate, not with the letterpad unions. You may know, you as management representatives, you may feel uncomfortable, but get used to it. You will know who is your person with whom you have to negotiate. It will bring some orderliness. I know many foreign companies are allergic to trade unions. They want to, the IR person given the first task is there should be no trade union. We should have only contract labor. We should have less permanent workmen. I all pity you because I also studied uh, uh, diploma in School of Social Work in personal management industrial relations. I joined a lawyer's office who is a labor lawyer. So after 2 or 3 years, I was not making any progress at all. I didn't know what I am doing. So I told my senior, put me in some company, sir. He said, no, no, wait. I'm happy that he said no to me. Because even at 70 years, I'm making money and practicing it. After 50 years, all of you will retire. And in between your 25 years to 58 years, You have to manage this demand. No union, no permanent workman, only contract labor, etc. It's a uphill task. And this type of vacuum has resulted in more problem. So let's welcome trade unions with a recognition. Yeah. Yes. I'll just run through it. Then quickly. Okay. That's also okay. 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 Yes. I'll just say what the court failed to consider. We have not noticed it since I am practicing. There is a section called 40, which is 9A. For change of service conditions, I have to get the approval of the union, etc. This should have been done away with it. Next. Permission. The officers, sir, don't take photo, you'll get it. Don't worry. Section 90 is another a curse. The unions are very smart nowadays. The moment you take disciplinary action against workmen, they will raise an industrial dispute. Whatever is filed is taken as industrial dispute. During the industrial tribunal, we cannot terminate the workman. There should be a mini trial. That should have been done away with it. Yes. Okay. These are all my thoughts. You can go through it. Because in court also, when the judge starts looking here and there, I know I have to stop my argument. Similarly, I have been said that there is going to be a question and answer session. Any questions to the best of my ability, I will reply. Yeah. Any sir, any other questions?
Some questions.
It's
Sir, here,
it's
please,
there.
question are there. Sir, these are the questions which are coming online, including questions here.
Yes.
It's come from here only. So you can just sit here.
Okay. What is it? What is this?
Flexibility. manpower
It is my note. My note. It is my note. Don't put that question. Yeah, don't put that question to me.
Oh, never proceed. Sir,
Yes, yes, yes. Any questions? I'll have a look at it. Asked on NMM, if these codes are good for employees, then why some union are opposing and called for strike? What is the role of HR, etc., etc.? That's why I said union leaders who are well read and well informed are also opposing it, not knowing that they are in 2025. They are no longer in 1960s, etc. We should, the union leaders have a duty to educate the workmen that we should work hard and we should not frequently go on strike. I don't know, what is that next one? Good, bad, ugly, we do not know. Let us see in due course. What's the second part of that question? What is the procedural changes under the Treasury Code affect standing orders, retrenchment? I told you, less than 100 you can retrench. Otherwise, you should get the permission, etc. So, all of you just click that chat GPT, you'll get all the answers. You ask, the chat you say, what else you want? You want comparison, you want silent features. It gives everything. But 50% correct thought, unless quantum comes, this thought will not be there. Sir? Yes. No. I'll explain. This is fixed term is a short time life. You are in ICU. Once it is removed, you will die. But permanent status is you work for 480 days in 24 calendar months, you become permanent. That law will be in force in Tamil Nadu because it is only 29 central acts. The central government has not annulled or repealed any state laws because they cannot do it. So both operate on different fields. Yes, of course. Yes. So if you have fixed term for 3 years, so 480 days, it becomes permanent. See, this fixed term also gives all the benefit of the permanent workman. But what it is, the day you are born, your date of death is also fixed in fixed term. That's all. How to be safe on keeping standing orders so that employees will not be face legal consequences? I do not know, sir. Okay, next. Ravindran, what key clauses should the employers include in mandatory written appointment letters to ensure legal defendability on misconduct, discipline, and termination? You add whatever you like. No, I am not saying jokingly. Smoking. For example, in a hazardous industry, smoking. In a five-star hotel, asking tips. In that industry, it will be a misconduct. Sleeping while on duty. Judge sleeping on while duty is not a misconduct. Workman as a clerk sleeping on while duty is not a misconduct. But a boiler operator sleeping becomes a grave misconduct. There is a classic judgment of Madras High Court saying railway attender, those days it is manned. If he goes on sleep, it becomes a serious misconduct. Similarly, a person who sets the question paper, he wrongly keeps that plus and minus sign, making many students to fail. It becomes a serious misconduct. But don't invoke the misconducts many times. You will land up only in court. Just let's leave it. Less standing orders, less misconduct, more peace. Like come across standing orders, misconducts are nearly 200, etc. I asked them, how many times you even read this? Nothing. Don't worry about it. Criteria for recognized trade union affect the collective bargaining in multi-union. No, this cures the rivalry. It does not affect multi-union means show the 51 percentage strength and you will be the bargaining agent. If you don't have 50%, 51%, 20, you will have one person each. Your life is 3 years or 5 years. You should welcome that. Higher courts strict strike notice norms change the union and employers' responsibility and safeguards should management take. Let us wait and see whether this strictness has really made the unions think twice. Let us see. You have a session on this after 2 years, we will be able to know it. How the new IR Code 20 will improve non-manufacturing organization like IT industry when severance concept is there. Nothing is nothing. IT industry is in a different world. They think none of the labor laws are not applicable, and the employees are also thinking so. That is a point. That's why we have only few IT related cases in reported cases at least. So IT is not subject to labor laws. What procedural changes under the IR code affect the standing orders? I already told you. Okay. Okay. This question was put before I started my speech. Okay. Thank you.
Ladies and gentlemen, I think we are on time, and I think he deserves a big round of applause. Such a It was really a master class, I must say. Such a serious subject, industry relation code. But I think by the time Sir has finished, sir, with so much humor, you brought out so many facts. Thank you so much. Time for us to honor the guest of the day. May I request Group Captain Vijay Kumar and Mr. Matthew to come on the stage and present a memento on behalf of both NIPM and MMA, please. So, fabulous session. Thank you very much. Very practical inputs. Ladies and gentlemen, it will be available during the lunch session. If any of you want to interact with him and clarify your personal or whatever professional doubts.